question is, what type of trust do we want to have? And what are the two basic kinds of trusts? Revocable and irrevocable. A revocable trust is very appealing psychologically. They sell them, Susie Orman sells them on QVC. You can download them for free off the internet. A revocable trust does one important thing. It prevents the property from having to go through probate. And it's, again, appealing psychologically because I can be my own trustee. I can put the assets in the trust. I can pull the assets out of the trust. But if I can get my hot little hands on the assets whenever I want, so can my creditors, so can my nursing home. So a revocable trust is like water in terms of protection. It does not give the asset any protection. If I have a multifamily rental property owned by a revocable trust, and a crazy tenant trips down the stairs and breaks his head while he was totally drunk, by the way, who's on the hook? They're going to sue me quite successfully. So if our only goal on this earth is to avoid probate, then we want a revocable trust. If we have any other goals, such as asset protection from the trip and fall people on this planet, and we also want to protect the real estate or the co-op from long-term care claims, then we want a stronger type of trust. But one of the few concrete takeaways that I want you to have in your heads is that there is never a good reason to have a totally irrevocable trust. A totally irrevocable trust means I appoint you as my trustee, you are my beneficiary, and I can't change that. There'd never be a good planning reason to do that. And I suspect that there are folks out there doing this area of law who don't know where exactly they need to stop on this continuum between revocable and irrevocable. So they err on the side of caution in their minds and they just go totally irrevocable. That's a disaster because it will result in carryover basis for capital gains tax purposes. If I bought the property in 1978 for $50,000 and it's now worth $1,050,000, and I either mistakenly transfer it directly to my kids, and that is a total no-go, because if I put the property in the kids' names, I will lose my STAR tax exemption. The kids, my grandkids, are going to get less college financial aid because that piece of real estate is in my children's names. That has to go on the financial aid disclosure. And the kids are going to have to pay capital gains on the difference between mom's original $50,000 purchase price and the then fair market value of $1,050,000. So an outright gift to kids or a totally irrevocable trust will saddle the beneficiaries with capital gains, and the homeowner will lose their STAR property tax exemptions. Okay, so we generally want to be between those two inadequate extremes. We want, in most cases, something that I think of as a hybrid trust, where I can retain as much control as possible over things without it tipping into the camp of being a revocable trust. How do I accomplish that? Well, I must appoint one or 2 other people as the trustees. So I appoint you 2 as my trustees. But if the trust is properly drafted, I will retain the ability later on, whenever I choose, to go into the document and change my trustees for any reason or no reason at all. I can have the 100% right to change the trustees without it affecting the asset protection nature of the trust, because I would not put myself in there as my trustee. If I'm in there as my trustee, it's in the revocable trust camp, and all bets are off. If I get sued, they would have a piece of the house. I can further stipulate that the trustees have no power to do anything without my written permission. So if I'm concerned that I don't want to give up control to whoever the beneficiary is, I want to retain the ability to veto anything that they want to do. How does this protect me? Well, we have one stipulation. In order to sell real estate that's in this trust, again, the trustee can't do it without me, but in order to sell real estate owned by the trust, we need my signature and we need the trustee's signature. The requirement of that wingman is what enables me to say, I can't get at it acting alone. And that is legally true. I have my trustee together with me, and that forms the magic power. We can sell it, we can mortgage it, we can do whatever it is that we want. Playing devil's advocate, what happens if the trustee says, I don't think that's a good idea for you to sell? What will I do? I'll replace them with a yes man or a yes woman. I'll give someone out on Francis Lewis Boulevard $50 to be my new trustee, to give me that magical signature so I can do what I want. So the trustee, if the trust is properly drafted, you could have a disaster of a trust. The trust has to say that they have no power to act independently of the grantor. We also want to say that Mary, Susie, and Johnny are my beneficiaries, but we want to retain the ability to make changes to that. Not that I would probably ever want to make a change, but if I hold the puppet strings and I control who gets what later, A, it's not a completed gift into the trust, so we don't have to do a gift tax return. And B, if any of my named beneficiaries have legal liabilities and mama can pull their interest away, then the plaintiff's attorney attaches to nothing. Because I retain something called a special power of appointment in the trust, it protects the assets in the trust from the kids' divorces, car accidents, and other lawsuits. Does anyone have any questions on this trust? Yes.
If the person is approaching the arrangement, it should be a different trust, like more specialized.
So for someone who is dealing with a cognitive issue, or any other possible long-term care problem, a stroke, Parkinson's, if we're concerned that long-term care may be on the horizon, then yes, we want to get this trust established as soon as possible while the person has capacity. Because once the person no longer has capacity, you can't do anything. So folks come into my office and they want to do a trust for their parents, but if the parent has dementia, the ship sailed, and now we're in court, depending upon what state we're in a conservatorship proceeding, like Britney Spears. And did anyone follow the Britney Spears case? You know, going back to the original conservatorship petition, the judge first asked, does Miss Spears have advance directives? And she was already, I think, in her early 20s at the time. She should have had a healthcare proxy and a power of attorney. If she had a healthcare proxy and a power of attorney, she could have saved herself the next 13 years in a conservatorship proceeding. So whenever, you know, we may have a little cognitive issue on the horizon, we want to, you know, hurry up and create this type of trust. So this type of trust is for definitely the primary residence. Because of how the trust is drafted, you get to keep your star property tax exemptions. That was not the law before 1998, but during my misspent youth in the legislature, that was my bill that then Governor Pataki signed, saying, if you transfer your primary residence into a trust, that retains for you 100% of the ownership rights during your life, then you get to keep your star property tax exemption.